Why earnest money is more than just a deposit. As we move forward from identifying the parties and property, the next critical step in the contract is establishing financial commitment. Earnest money is often misunderstood as simply a good faith deposit, but in commercial real estate it serves a much larger purpose. It is the buyer's first demonstration of intent and one of the strongest indicators that a contract is serious and enforceable. Earnest money connects directly back to consideration, one of the essential elements of a valid contract discussed in Chapter 1. Without consideration, there is no enforceable agreement. Earnest money is often the most visible and immediate form of that consideration in a commercial transaction. Timing requirements, where deals commonly break down. The 2026 Commercial Real Estate Purchase Contract outlines that earnest money must be deposited within a specific time frame after contract acceptance. This is not just a procedural step, it is a contractual obligation. Failure to deposit earnest money on time can constitute a material breach of the contract. In many cases, the contract provides a cure period, allowing the buyer an opportunity to correct the issue. However, if the buyer fails to cure, the seller may have the right to cancel the contract. For example, a buyer enters into a contract for a multi-tenant office building in Tempe, but delays depositing earnest money beyond the agreed time frame. The seller issues a cure notice. If the buyer still fails to perform, the seller can cancel and move on to another buyer. This highlights a key takeaway. Timelines in commercial contracts are not flexible suggestions. They are enforceable obligations. Forms of earnest money, understanding the options. Earnest money can take several forms, including checks, wire transfers, or other agreed-upon methods. In commercial transactions, wire transfers are often preferred due to speed and reliability, especially in high-value deals. The method of delivery matters. If the contract specifies a wire transfer and the buyer delivers a check instead, this could create delays or even disputes. As an agent, ensuring that your client follows the exact terms of the contract is part of your duty under AAC R4 28-1101 to exercise reasonable care. Earnest money as a risk allocation tool. Earnest money is not just about securing the deal, it is also about allocating risk between the parties. If a buyer defaults without a valid contractual reason, the seller may be entitled to retain the earnest money as liquidated damages. This is where commercial transactions differ significantly from residential deals. Earnest money amounts are often much larger, sometimes representing a significant financial exposure for the buyer. For example, a buyer places $100,000 in earnest money on a commercial retail center. If the buyer fails to perform after the due diligence period without a contractual right to cancel, they may forfeit that entire amount. This reinforces the importance of understanding contingency periods and deadlines, which we will explore further in upcoming sections. Escrow and handling of funds. Compliance matters. Earnest money is typically held by an escrow company or a neutral third party. This ensures that funds are properly managed and distributed according to the terms of the contract. Under Arizona law and ARS, paragraph 32-2151.01, brokers are required to properly handle and account for all monies received in a transaction. Mishandling earnest money is one of the fastest ways to face disciplinary action. For example, if an agent receives earnest money and fails to deliver it to escrow in a timely manner, this could be considered a violation of trust account rules and may result in penalties from the Arizona Department of Real Estate. Real-world breakdown, when earnest money becomes the dispute. Let's walk through a real-world scenario. A buyer enters into a contract to purchase an industrial property in Glendale and deposits earnest money. During the due diligence period, the buyer discovers environmental concerns but fails to cancel the contract within the allowed time frame. After the due diligence period expires, the buyer attempts to cancel and requests a return of earnest money. The seller refuses, arguing that the buyer no longer has a contractual right to cancel. The dispute now centers on the earnest money. The outcome will depend entirely on the contract terms and whether the buyer met the required deadlines. This example shows how earnest money is not just a deposit, it is often the central issue in contract disputes. Connecting consideration to contract strength. Earnest money is one form of consideration, but consideration can also include financing terms, concessions, or other negotiated benefits. The key is that something of value must be exchanged. In commercial transactions, stronger consideration often leads to stronger contracts. A higher earnest money deposit may make an offer more attractive to a seller, while also increasing the buyer's risk. As an agent, your role is to help your client balance these factors, making the offer competitive while managing exposure. How this section connects to the bigger picture. This section builds directly on the foundation of contract validity and formation from Chapter 1. Earnest money and consideration bring financial commitment into the transaction, transforming an agreement into something enforceable and meaningful. As we move into the next section, we will begin exploring due diligence and contingencies, arguably the most critical protections for buyers in commercial real estate. This is where earnest money, risk, and timing all come together. Online discussion. Why is earnest money considered a critical part of a commercial contract? Answer. Earnest money demonstrates the buyer's commitment and serves as consideration, making the contract enforceable. It also acts as a risk allocation tool, potentially becoming liquidated damages if the buyer defaults. What happens if earnest money is not deposited within the required time frame? Answer. It may be considered a material breach of the contract. The seller can issue a cure notice, and if the buyer fails to comply, the seller may cancel the contract. How does earnest money create risk for a buyer? Answer. If the buyer fails to perform according to the contract and does not have a valid reason to cancel, they may forfeit the earnest money, which can be a significant financial loss in commercial transactions.